next case is USAA versus Thames and Madrigan. Counsel for the appellant, ready to proceed?
That's right.
Please come forward.
May it please the Court, Elliot Shurker with the Greenberg Traurig Law Firm on behalf of the appellant USAA. I'd like to reserve 3 minutes for rebuttal, if I might. The trial court certified a class of Florida USA insureds on a claim that USAA authorizes the use of aftermarket or so-called non-OEM parts to repair insured vehicles in alleged violation of the contract of insurance as an injunctive relief class only, with a class represented by the appellee Madrigans, who are not insured by USAA, who do not live in Florida, and who seek relief that, if granted, would operate to the disadvantage of those USAA insureds who happily pay lower premiums because USAA authorizes the use of non-OEM parts to repair their cars. And where, even if the class could be seen as sufficiently cohesive to allow certification under 1.220B2, the Madrigans' claim is essentially for monetary damages, the difference in the money that they believe they're entitled to and the money that they got from USAA. Turning first to the question of their adequacy as class representatives, which essentially merges with the typicality factor. Together, those two factors ensure that the class representative, as the United States Supreme Court has said, are part of the class and possess the same interest and suffer the same injury as the class members. There are 2 reasons that the Madrigans are inadequate class representatives. First, they do not have standing to pursue a claim for injunctive relief, and second, their primary interest, as I said, is in collecting their damages. The undisputed facts are that the Madrigans were not insured by USAA when they brought this action. They have not been insured by USAA since May of 2000 when they left Florida and moved to California. They have no standing to seek injunctive relief against USAA. We cannot have a class of Florida USA insureds represented on a claim for injunctive relief by California residents who are not USAA insureds and have no interest in pursuing a claim.
Are they California residents, or do they just live in California?
Well, there's some dispute.
Where you live is not the same as residents.
They are living in California. There's no dispute. But
does that make them a resident of California?
The important fact is that they're not insureds. They could be living in Florida. Our position would be exactly the same. It makes them a little bit more removed from a Florida class, of course, and that gets into their factual adequacy. But in terms of standing, it doesn't matter where they live. They're not insureds. They could not come before the court as a plaintiff, not as a class action, a purported class action rep, and seek a claim for injunctive relief that they have no interest in pursuing. It's black letter Florida injunction law. You can't use injunctive relief to get damages or to redress past wrongs, and that's all that they have standing to do. Class representatives who don't have standing to seek injunctive relief, as we cited in the cases in our brief, cannot serve as class representatives of an injunctive class. But even if they did have standing, they would be inadequate class representatives, not only because they live in California and are far removed from the class members. They frankly admitted their lack of interest in the litigation. Their deposition testimony is quoted at page 29. Mr. Madrigan hadn't read the second amended complaint. He really didn't want to spend a lot of money on this. His wife said, I rely on whatever my husband tells me and whatever the lawyers tells me. But more importantly, their only legitimate interest is in recovering their damages. They have no legal interest in obtaining injunctive relief. That creates almost a per se conflict under the case law with those class members who are USA insureds, which is virtually the entire class, I presume, and have no interest in recovering any damages against USAA, and if they have any interest at all, would be only interested in securing relief on a future basis, that is, injunctive relief. The undisputed evidence that we submitted to the trial court from Dr. Blair's submission is that forcing USAA to use only OEM parts would cause premiums to increase, which of course stands to reason. USAA adopted the QRP program, the program that authorizes the use of certified non-OEM parts to save money for its insureds. Not, I should point out, as Dr. Blair's submission shows, to maximize their profits because USAA is a member organization and the money flows to the benefit of the members of the organization. But in any case, the premiums would be forced to be increased to maintain the cost of using only OEM parts. The Courtesy Auto Group case on which we rely is on point, and actually the Madrigans are in a worse position than the purported class representatives in that case. The plaintiff sought rescission of certain auto leases based on some complaint about disclosure of documents. The named plaintiff also sought damages, and the Fifth District held that merely because the named plaintiff was also seeking damages, remember, that plaintiff had standing at least to seek rescission, to seek equitable relief, necessarily put her in conflict with the members of the class because of the concern that a plaintiff who seeks damages might use the class action as a leverage point, as a tipping point to recover damages, to get a settlement for damages from the defendant, and leaving the plaintiff class members who only have an equitable claim in the lurch. But even if the Mondragons are adequate class representatives, and even if they had standing, the B-2 certification has to be reversed. We submit the trial court failed to conduct the rigorous analysis of class certification that is required by Florida law. Here the court left the critical question on a B-2 class for the jury. The critical question on a B-2 class, of course, is the cohesiveness of the class, which essentially means the defendant has to have acted in the same way toward all members of the class so that group injuries as opposed to individual injuries can be redressed. And, of course, that's what a B-2 action is all about, what a class-wide injunctive relief action is all about. Here's what the court did. This is our appendix at page 26, pages 15 through 16. The court certified the class because the Mondragons' allegations, quote, if proven at trial, would show that USAA, quoting again, has acted in a consistent manner toward members of the class. Now, the Mondragons said, well, of course the judge had to do that because you're not supposed to address the merits of the claims on a certification application. Of course, that's true, and it doesn't mean anything in terms of what the trial court did, because as the United States Supreme Court has recognized, as every court to look at this issue has recognized, you have to go beyond the pleadings. If the question is, can you certify a class because the defendant acted in a consistent manner toward all members of the class, the burden is on the plaintiff not only to plead that the defendant did so, but to prove that the defendant did so. Otherwise, you have a conglomeration of individual claims slammed together in a class action. Class-wide relief cannot possibly arise for each individual plaintiff on a claim for damage from the use of non-OEM parts. Theoretically, you could do what the plaintiff seemed to want to do on appeal at least, and which is a lot less than they asked the trial court to do, and to pluck out one issue, the theoretical issue of are non-OEM parts categorically inferior all the time, in all cases, for every single part, without examining any parts at all. And they have someone who said that, yes, I can do that. I can testify that that is so. The question whether it's so, of course, is not the question of a class certification. The question is, could they try that issue? And theoretically, I suppose they could try that issue. They might have an interesting time trying it, in as much as the Florida Department of Insurance authorizes the use of non-OEM parts of like kind and quality, and therefore assumes that they can be. But they theoretically might be able to try that issue. The question is, what would they have at the end of the day? They have no case for damages, because our obligation is to pay an amount of money to an insurer to repair the vehicle with using parts of like kind and quality, and not to fix the car. As a matter of fact, the Mondragons didn't get their car fixed. They got money. They want more money. And that's all it's about. And that really gets to what...
Well, they would have had the car fixed had they used cheap parts, right?
They could have had the car fixed if they used the non-OEM parts.
The reason they didn't, if I understand correctly, the reason they didn't get the car fixed is because of your client's refusal to use original parts. Is that right? We
offered non-OEM parts, and they said no.
Right.
Yes, so they didn't get the car fixed, and they took the money. And they'd like more money. But that gets back to what the plaintiffs
maybe they used the money to buy OEM parts, and they're just looking to you for the difference.
I don't know if they did or not, quite frankly. I don't know if the car has ever been repaired, because the car has never been examined since it wasn't repaired, and it's moot as to what the parts are on the car. But, Your Honor, I refer you to page 34 of their brief, because I think it's the perfect answer to your question. And quoting exactly, they say the Mondragons, quote, do not have an individual damage claim other than incidental damages flowing from the declaratory relief. Now, you can read all of the complaints, including the one originally filed on behalf of Ms. Thames, and all the way through the second amended complaint. There's no claim for declaratory relief that's specifically pled in the complaint. The only claim is for breach of contract, and damages from breach of contract. In their prayer for relief at the end, they ask for injunctive relief, they ask for damages, and they say, tell USAA not to do this anymore. I suppose they're calling that now their claim for declaratory relief. So they say that not only does that give them standing, because they don't really want injunctive relief. They just want this unspecified declaratory relief. What it really does, and I turn now to their brief at page 45, is it gives them the end run around a B3 certification. Every case that both parties cite including their Avery case, their case from Illinois, which is still pending in the Illinois Supreme Court, were B3 certifications. Illinois was a different kind of B3 certification because they have a different class action rule. But they were all B3 certifications. We claim for damages. We like people classified claim for damages. Now, most of those cases, as we point out in our brief, particularly the Florida trial court cases, have not gone the way of plaintiffs who want to make claims about non-OEM parts. So what they've done here is they've pled a claim for breach of contract. They've sought and awarded damages on behalf of the Modrigans and theoretically on behalf of all the other plaintiffs. They admit that their only real interest, of course, is seeking damages, and what else could it be? And I think that shows the fallacy in their declaratory action argument, because what they seek, Your Honor, is a declaration on an element of liability, and that's all. They're not even seeking a declaration of liability, which it appeared they were seeking in the trial court. They're seeking a declaration on one factual issue of liability. And based on that declaration, they say that they can then bring a lot of individual actions to recover damages. Their claim is that USAA didn't pay enough. They say at page 42 of their brief, quote, "This case is not about individual car parts." That's right. This case is about money. And buried in a footnote, on page 33 of their brief, if I might, Your Honor, injunctive relief in this matter would necessarily flow from any declaratory relief awarded in plaintiff's favor. Hundreds of thousands of current USAA policyholders would be able to utilize that ruling and a court of law to obtain his or her own individual judgment under his or her current insurance policy. That's what this case is all about. They're not certified. They don't dare try to certify a B3 class because they can't. It's individual claims for damages. So they're using the B2 artifice to say we want a declaration, not even an injunction, because we know we can't ask for an injunction, on one factual issue, and then hundreds of thousands of people in this class will then be set free to try their individual claims. A B2 class, however, requires a cohesive class where group injuries can be addressed in one trial, and most importantly, where monetary relief does not predominate. By their own admission, monetary relief predominates. Everything they're trying to accomplish by certifying this class is to create a platform from which individual plaintiffs can sue USAA and prove that they didn't get enough money and that they're entitled to more money. That's not a B2 class. Thank you.
Thank you, Mr. Sheriff.
May it please the Court. Your Honors, Richard Lantenberg on behalf of the appellees, the Modrigans. There are three fundamental flaws with USAA's argument. First, USAA misreads the Court's order. Second, they misapprehend the nature of the claims sought by the Modrigans. And third, they misunderstand the record. Reading of paragraph 40 of the Court's order, Your Honor, we think is instructive. In paragraph 40 of the trial court's order, the Court found the plaintiffs have successfully demonstrated that injunctive relief sought by the plaintiffs, namely requiring USAA to comply with its coverage obligations under its policies of authorizing money for the use or cash equivalent of parts of like kind and quality, is the type of class-wide relief ideal under Section B2. Respectfully, Your Honors, the type of injunctive and declaratory relief that the plaintiffs in this case seek is a requirement that USAA comply with its obligations under the policy. As Mr. Shurker points out, USAA doesn't repair cars. The insuring agreement provides specifically, page 3 of the initial brief, that they pay for loss. And USAA has an obligation to pay for loss under the contract consistent with its contractual obligations, which, as we know, are strictly construed against insurance companies, more so than even contracts strictly construed against drafters. So what we want the Court to require, ultimately, a declaration of what like, kind, and quality means. And the Court, with respect to the issues of typicality and adequacy and commonality and numerosity, all of those, of course, are subject to this Court's review on an abuse of discretion standard. And the Court found all of the arguments that Mr. Shurker makes were made before the trial court. The issues relating to Dr. Blair, the issues relating to Florida residency, all of these things were provided in a point-counterpoint before the trial court and rejected. And this appellate court should, of course, only review those issues on an abuse of discretion standard. But this is not a case in which damages predominate. The relief that the plaintiffs seek is the mandatory injunction to make USAA go back and readjust the claims properly. As the Court knows from the record, a USAA adjuster goes out and identifies the physical aspect of the vehicle that was damaged. And then on a computerized system that the record also makes clear is never to be turned off. This is something USAA tries to de-emphasize. The cohesiveness of this class is embodied in the requirement, the QRP program, USAA's corporate-wide program, that it never be turned off. And the implementation of the non-OEM part selection is through the ADP system. The cohesiveness is, as alleged in the initial brief of USAA, is lacking because they say that there's a level of discretion. And they also cite to the Court the case of Schwendeman versus USAA. The Schwendeman case is particularly distinguishable from this case for a very primary reason, which is in that case, USAA presented to the trial court, which apparently was accepted, an affidavit of a USAA employee, a Mr. J. Bower, if my memory serves me right, that indicated that there's a wide level of discretion that is afforded the adjusters. The record in this case, and I would encourage the courts to reread the Van Adder testimony. Mr. Van Adder was a parts manager at a Jacksonville dealership, Gordon Chevrolet, that they brought in to testify by affidavit, and whom I took the deposition of, to say that there's a level of discretion in connection with the placement of a non-OEM part on the car. And what the transcript of his deposition reveals is that what Van Adder is saying is that their first obligation, and I believe this is at page 42 of Mr. Van Adder's testimony, it's under volume 3, appendix item 22, subtab number 2. Mr. Van Adder's testimony is that they're required to put the part on the car first, the non-OEM part. And if that part is so visibly and obviously non-complying, it doesn't make the car look right, doesn't even pass a smell test, then they can take it off and put an OEM part on the car. And it's important that the court realize this temporal component. When the car is damaged, the first thing that happens is that it gets adjusted by a USAA adjuster. And the record is undisputed in that regard. Only USAA adjusters can adjust the vehicle, and the ADP system must be used and it must be turned on 100% of the time. And the record before the trial court reflects that, and I would encourage the court there to look to appendix item 15, sub-item 5 at Bates page 1210. And there it indicates that it must be turned on 100% of the time. So the temporal component that I want the court to recognize is that when the claim is adjusted, there's no discretion exercised. There's an allegation that they can look at see if the car has been damaged, or if it's rusty, or if it's been waxed, or if it's in better shape. And this was one of the issues brought before the trial court during a rigorous analysis of the record. And as the court knows, of course, it's the plaintiff's burden to support all of the allegations with respect to sections A and B of Rule 1.220. And during a 3-hour evidentiary hearing before the trial court, and again, I'd encourage the court to read that record, I presented on behalf of the plaintiff class. We made specific references to both testimony and documents of USAA that support each and every element, the commonality, the typicality, the numerosity, and the adequacy, all of which the court had an opportunity, of course, to counterbalance with the presentation of USAA. And I think it's instructive and informative to read that transcript, because USAA didn't do that. USAA did, as it's doing here, is arguing some theoretical inabilities to prosecute this case as a class, a suggestion that we'd have to look at every car, we'd have to look at the repairs now. They're suggesting that the court or a court evaluating this case would have to look at the current state of the car. All we want, remember, USAA doesn't repair cars and USAA doesn't source parts. All USAA does is pay money. And the contractual obligation is that they're going to pay a sum of money that will replace the damaged part with a part of like kind and quality. Now, that's the ambiguous phrase that we want the courts to declare. What does that mean? What is that obligation? And then ultimately, for the trier of fact, on the class-wide evidence of such people as Mr. Griglio and Dr. Woods, would be to demonstrate to the ultimate trier of fact that what USAA actually does not comply with its contractual obligation as declared by the court. And so it's in that way that, of course, the Modrogans, who were insured at the operative time, suffered an injury, a compensable injury under the policy, had their car adjusted, and as the court recognized, did not get the sum of money that we allege in this case is the proper sum of money, the contractual obligation of USAA. So we want the court to declare what the obligation is, the trier of fact, of course, to determine whether or not what they do complies with that obligation. And then, of course, from that, the injunctive relief from the court would be to direct USAA to go back and adjust the claims as it's required to under the policy. And from that, incidental to that, would be the flow of damages as to the differential between what was put on the car and what they were required to put on the car. So this is not a case about parts or repairs. It's about USAA's contractual obligation. USAA has also suggested that there's some requirement that, or some sense that we don't even know what actually went on the car. There's a suggestion that they don't know if the car was actually repaired consistent with the appraisal. I'd suggest to the panel that that is a red herring. First of all, USAA, and again, this is in the testimony of Mr. Van Adder and Mr. Viverette, USAA only pays based on the actual parts put on the car. And there is an obligation, I would submit to the panel, that it's insurance fraud to submit something different. There's an obligation that what they ultimately submit for reimbursement from USAA match what they put on the car. So if the initial appraisal says we're going to put on a non-OEM hood, a non-original equipment manufactured hood, and they ultimately put on a real hood, the actual appraisal reflects it. And so therefore, this level of scientific precision that USAA demands, one, isn't reasonable. Two, of course, it's inconsistent with the very business practice of USAA. And, of course, the only standard of proof here is a preponderance of the evidence, not this scientific level of precision that USAA has advocated to the trial court, which is why we believe the trial court properly certified the class, properly found on all of the adequacy issues with respect to the Modrogans. The USA suggests, and as the court pointed out, the Modrogans do live in California. And as the court also knows, USAA is primarily caters to the military. Mr. Modrogan has his cars registered in the state of Florida and carries a Florida driver's license. He was stationed in Pensacola when he was restationed into California. Just as this court would presumably not ascribe residency to one of our soldiers in Iraq to being a resident of Iraq, the Modrogans aren't residents of the state of California, and they are properly before this court and can properly stand for the class that they seek to represent for Florida residents. The rigorous analysis, I think, is really important for this court to understand. Prior to the 3-hour evidentiary hearing in December of 2003, the parties entered into a stipulated case management order. That stipulated case management order set out the briefing schedule for the court and the ultimate scheduling of a 4-hour hearing before Judge Taylor. In December, we had that hearing, and we presented to the court the record evidence, and the court commented on the volume of materials before the court. And the court, of course, can read it, but appreciated the presentation and had a number of salient questions, one of which was, the Department of Insurance mandates that you can use OEM parts. That doesn't create the ceiling of responsibility for USAA. It creates the floor. And USAA has a contractual obligation that it wrote that it should be required to fulfill. And I simply point that out as sort of a commentary on the level of analysis and the things that the court did. But subsequent to the December hearing, the court instructed counsel for plaintiff to prepare an order consistent with a letter. The judge said, I'm going to certify the class. I find the following. Please prepare an order. We prepared an order. We circulated that order to defendants. The defendants had commentary to it. They had changes to it, many of which were adopted, some of which, of course, were not, all of which were submitted to the trial court. The trial court then received a motion for reconsideration, a motion for re-argument from USAA, at which time the court entertained again USAA's repeated arguments, those asserted at the evidentiary hearing on class cert, but to reassert their reasons why they disagree with what the court did. It's sort of a not argument. They don't like the fact that the case has been certified, and they have a number of reasons. But all of those were presented to the trial court. The court made some additional commentary and changes and suggested certain things be done to the order. A new order was submitted to the trial court. The trial court then wrote back and had interlineated by hand, both crossing off aspects of the order that it liked and aspects that it didn't like, and ultimately that was the order that was entered. So the notion of a failure or a lack of a rigorous analysis, I respectfully submit, it doesn't go anywhere. This case should be affirmed for all the reasons that the trial court properly exercised its discretion. The notion that there's a lack of standing is simply erroneous. There's no motion to dismiss the claims of the Modrogans, and they clearly have standing to bring the claims that they brought. The concept of antagonism. Of course, one, that is a concept embodied in adequacy, and the Modrogans were clearly adequate as found by the court and should really only be disturbed on an abuse of discretion standard. But the notion that a former insured cannot represent a group of former insureds and or current insureds is simply misleading. As the court knows, and we've cited this in the brief, in the Caranci versus Blue Cross Blue Shield case, the magistrate judge recommended to the district court the certification of a class, a B2 class, in which two of the class members were not former insureds. Were formerly insured with Blue Cross Blue Shield, but at the time of the certification were not. And the court had no problem accepting them as class members. The court also goes through an analysis of when there might be a potential conflict that would warrant the sort of antagonism that would warrant finding a class rep inadequate. And there the court focused on the nature of the relief sought and the nature of sort of this economic antagonism. And in that case, well, the situation here, of course, is that there's an allegation, and it's not an unrebutted allegation. They have an expert on this point that they said the premiums would go up. Mr. Modrogan testified quite clearly that his premium didn't go up, and he has a policy now that does authorize non-OEM parts. So it's not unrebutted. It certainly is challenged, and certainly we think that the trial court properly found on that point. I think the cohesiveness point is very important. There is no discretion here. There's clearly cohesiveness. These are all the parties that they're all exactly the same. They were required to get the parts. They were sourced, and then ultimately the actual appraisal reflects the what was put on the car. I appreciate the court's indulgence, and please affirm the trial court's order. Thank you.
Okay, thank you, Mr. Lattenberg.
As I understand the appellee's concluding argument, we fought very hard against class certification, and there were a lot of proceedings on class certification, so the trial court must have conducted the requisite rigorous analysis. But the trial court's order makes no findings on standing. The trial court doesn't analyze how it is that a non-insured can seek future relief, can seek injunctive relief on behalf of a class of insureds. The court's rulings on adequacy of 13 through 14 say nothing about how it is that the Modrogans can stand in the shoes, which is what a class representative must do, of a class of current insureds when they seek only damages. Courtesy Auto Group says they can't. The rigorous analysis that supposedly resulted from this long, hard-fought process in the trial court doesn't explain how it was that the trial court, at pages 15 through 16, left it to the jury to find whether or not there's the consistent practice that against all plaintiffs by USAA that would allow class certification in the first place. The trial court's discretion is a fine thing, and we set forth the appropriate standard of review in our brief, but standing, of course, is a legal issue. Where a trial court fails to conduct the rigorous analysis, the discretion has never been exercised. Where a trial court bases its ruling on allegations and doesn't resolve the critical issue as to how a class can be certified under B2, there's no question of discretion because the trial court never exercised the discretion in the first place. Now, in my opening argument, I noted how it is in their brief that they talk only about declaratory relief. But if you listen very closely to my opponent's argument, he says, we want injunctive relief. We want a declaration of injunctive relief, and then we want to be able to go and get our damages. That is not a B2 class. A B2 class can be certified where money is an issue only when any monetary award is incidental. They plead a single claim for breach of contract. How it can be said that money damages are incidental to a breach of contract claim defies explanation, and there's nothing in their papers that explains how that is. Again, they are shoehorning a bad B3 action into a B2 action, or it's a B3 masquerading as a B2. That's not the purpose of a B2 action. Now, there was a lot of discussion at the beginning of his argument about the QRP. The QRP is no secret. It's disclosed. It was disclosed to all of our customers. The Van Natter affidavit, which is in the record at tab 20 of the appendix, explains how it is that our body shops are allowed to work and are allowed to use OEM parts when a non-OEM part is inadequate for the job. The trial court did not exercise its discretion. The trial court made serious errors of law that doomed this class certification. Thank you.
Okay, thank you. Thank you both.